Where do I start it?
Well, I can start the broadcast on my end. I have a pop-up where I can click
Okay.
start broadcast. Should I do that?
Yeah.
Okay.
Hello. Welcome, everyone. I want to apologize now. I have 3 dogs, so if you do hear some sounds in the background, it is them. My name is Courtney Roca. I'm the Client Care Coordinator, Program Coordinator at Legacy Planning Law Group. Thank you for taking time out of your schedule to join us. All of us are going through some very trying times. This coronavirus has disrupted our lives. And for some of you, it's got you thinking about healthcare issues and planning for incapacity or end of life. Maybe this crisis has prompted you to look into doing this sort of planning. And for some of you, perhaps this is something you thought about before, but are really acting on. And many of you, I imagine, have questions. Maybe you're not sure how to go about it. Well, there's a chance to get your questions answered. Joining us today is Bill O'Leary, attorney and owner of Legacy Planning Law Group. We are a small firm that focuses on estate and elder law. Up on the screen, you'll see that our team, I like to call Team Legacy, actually works in the office with all women, and he's adapted very well. We thought it might be fitting to end the long, stressful week with a virtual gathering on this Friday. At a time where some of us would be happy, would be at a happy hour with our friends, we thought the next best thing would be a virtual happy hour. So if you want to unwind with a beverage, whether an adult beverage or not, I have mine, but it's iced tea. This is the place for you. And bring your questions and maybe even stump the expert. Before we get started, I do want to go over some housekeeping rules. On your screen on the right-hand side, you should see the control panel, and that is what's pictured in the actual slide. If you're listening using your computer, you will be using your computer speaker system by default. If you would prefer to join via phone, select telephone in the audio pane on the right-hand side and use the dial-in information that was provided to you in your email. You will have the opportunity to submit questions to the presenter today by typing your questions into the question pane on the control panel. We will do our best to answer all of the questions, so you don't have to be shy and ask away. We will be doing an icebreaker survey in the beginning of the night and a poll at the end of the night, so please participate in that. We will be recording this session and will make the audio available to you within the next 24 to 48 hours. If at any time you have any technical trouble, I will be available in chat to help with any of those concerns. I would like to thank you for coming to our virtual happy hour Q&A and introduce Legacy Planning Law Group's attorney, Bill O'Leary. Go ahead, Bill.
Thank you, Courtney. Good afternoon, everybody. This has been a very long week, a very trying week, and it looks like we have a good month of this ahead of us. And so hopefully everyone is adapting as best they can, is hopefully getting along with those that are under the same roof as you. And perhaps the time that you're now spending at home has got you maybe reorienting some thought processes or some, some perspectives. And so I thought it'd be helpful maybe at the end of the week to sort of create sort of a forum to answer any questions that you might have that relate to sort of larger life issues. Is everything that I have is in order if something should happen to me? Are my affairs in order? What about end of life planning? You know, if I become incapacitated, what happens? Who's gonna step in to make decisions for me if I have to get rushed to the hospital? And then even beyond that, well, gee, what if something tragic happens and I end up passing away? Well, what happens there? Are my affairs in order? Is everything going to be smooth and easy for my family? And so what I find that in times like this, people have lots of questions. There's a lot of information out there. Not all of it is good and reliable. And so I thought I'd sort of offer myself as a resource and answer these questions. And so, Courtney, I know you're going to be putting up some questions here in just a minute, but what I'd like to do is I want to share an example of, gee, are your affairs in order and what might happen if not? And actually, this happened late this morning, believe it or not. And we got a call from somebody whose wife is in rehab and had some medical issues over the past couple of months, has been in rehab for the past 3 weeks. And her husband has determined she is not improving. In fact, she is deteriorating. And this is not going to have a good outcome if she stays there. And so he wanted to take her home. In fact, he's trying to do that right now as we speak. Well, he's running into a major roadblock because he does not have a power of attorney. He does not have, she has never signed a power of attorney authorizing him to take this kind of action, to make this kind of decision for her. And while you might think, well, gosh, why would he need a power of attorney? They've been married, I think over 50 years. Well, even though you've been married a long time, that's just a basic requirement that you need that in place. So he doesn't have that. So it is now a little bit after 4 o'clock. I was last told that he was going to be showing up at 4 o'clock, possibly with a police escort to extricate her from that. So I would just raise the question, do you think there could have been an easier path for him? Easier path for them? And I think the answer is yes. So that's just one example among a number that we see all the time in our practice here. So with that said, Courtney, why don't you go ahead and tell us if anybody has raised their hand to ask a question. Fire away. Courtney, do you have any questions? Courtney, can you hear me?
Sorry about that. You forgot to do our icebreaker poll.
Okay, yeah, why don't you go ahead and do the icebreaker poll?
So we'll go ahead and do the icebreaker poll first, and then we can get some questions, because the first question we got, you actually kind of talked about already. So
okay.
If anyone else wants to put some questions up in there, I'll be happy to try and get those answered. But with our poll, our first poll is going to be about, what is your favorite ice cream flavor? So I'm going to go ahead and put that up there. If you could all vote. I've got a couple of them up. And then give it a few more seconds and I will close it. Shows that less than half of us have voted. All right, I'm gonna just go ahead and close it. And as you can see up on the screen, or you should see up on the screen, that 25% of you said that caramel was your favorite, and 75% said none of the above. My personal favorite is the mint chocolate chip that's up there. What's yours, Bill?
Well, I just like straight chocolate.
Straight chocolate? Okay.
Yeah.
All right. And then we do have another question. It's, can I handwrite my own will?
Can you handwrite your own will? Well, yes, you can handwrite your own will. It's not a good idea because a problem that can happen is if you put something down on paper, okay, and it's not as clear as it should be. And the last thing you would want is for somebody to come in and challenge what's in the will, okay, that there'll be a dispute about that, okay? And so having a handwritten will, if you're writing it in your own handwriting and not having somebody put it together that knows how to write those things, you're running a big risk. Secondly, by doing it by hand, you probably are not going to do the entire will drafting process in the correct way. What do I mean by that? Well, in order to have an enforceable will in Florida, you just can't write some random thoughts on the back of a napkin. It needs to be done right. It needs to be signed in the correct way. It needs to be notarized and needs to have witnesses and so forth. That is by far the best way to put together a last will and testament. And in fact, I've dealt with situations where somebody's sort of tried to do it themselves, writing it down by hand or even typing it up on the computer, and it turns out to be a real mess. In fact, we have one of those situations right now where it was somebody passed away. They had a life partner that they lived together for about 25 years. So he died. She's the survivor. He wanted to provide for her in this will that he put together himself, and he was not completely clear. And I told her, we're going to have a real problem with this. And so it's ending up costing her a lot more than the deceased man ever intended. So not a good idea. Certainly not a good idea to be doing it by hand. But thank you for that question. Any other questions, Courtney?
Should a power of attorney executed prior to 2012 be updated or redone?
That's a great question. And by the way, I should have mentioned that, we've called this the virtual happy hour for a reason. Obviously, it's virtual, but it's Friday at 4 o'clock. So don't hesitate if you want to break out an adult beverage. I actually have one myself. So powers of attorney that are older than 2012. So what's so significant about 2012? In 2012, there was a significant change in the law in Florida, the law that governs powers of attorney. The law was overhauled very dramatically, okay? And so what that means is that powers of attorney that were prepared and signed before 2012, while technically the law says that those old ones are still good and should be, accepted out in the marketplace by banks and so forth. Although the law says that, the reality is that banks simply are not accepting old powers of attorney. And there are a lot of these powers of attorney sitting out there that predate 2012. So anytime somebody comes in for a review of their existing, estate plan, I may look and see, well, your will or your trust may be just fine, but oh, that power of attorney that you have, and it's from 2007, really, we need to go ahead and update that. So it's probably a good idea for you to take a look at the power of attorney that you do have, if you do have one, and see if it is older than 2012. That's a good question. I get that a lot.
Another question is, if I have a will, my kids don't have to deal with probate, right?
Okay, so the question is, if you have a will, your kids don't have to deal with probate. Many people think that statement is true. And unfortunately, it's not. That is not a true statement. Okay, so first of all, what is probate? What is probate? Many of us have heard of probate, may not know exactly what probate is. Probate simply is a court process, a process where the court system, a judge, oversees how your estate is handled. Okay, well, so what's the big deal about probate? Well, there are two major problems with probate. Number one, it takes a long time. In fact, in my experience, the average length of a probate is 9 to 15 months. And in fact, we have some probates in our office that are well into year 2 because things sort of pop up unexpectedly. So that's what does that mean? It's a period of time during which your estate really is sort of in limbo. It's frozen and your loved ones can't get at what you'd like them to get. In fact, what they might even need to get. So that's problem number one. It takes a long time. Number two, it's expensive. And the primary expense involves the fact that the executor of the estate, who's ever handling it, has to hire a lawyer in Florida in most instances, okay? The law is very clear on that. Well, the lawyer is going to get paid for their service, right? And their fee is often a function of, it's a percentage of the value of your estate when you die, between 3 and 5%. So, you know, it is like taking money out of the pocket of your children. So, so some people have heard about this probate, heard generally about what I've described, and they've said, well, I don't want my kids to have to go through that. I'd like them to sort of get everything quickly and easily straight away. But then they say, but I've solved that problem, haven't I? Because I have a last will and testament. And that's not true. Having a will does not avoid probate. In fact, more often than not, having a will almost guarantees probate. So having a will, it's certainly a good start. It's better than nothing at all. It's better than that back of a napkin. But in many cases, particularly if you are middle-aged and up into our senior population, a last will and testament really is not good enough. And there are alternatives to that. Good question. Good question.
Can I add my kids as owners of my house so it doesn't have to go through court?
Okay, that's another great question. I get that question a lot. The short answer is yes, but then that leads to the question, is that a smart idea? So the short answer is yes. So let's say you own your house and you want the house to go smoothly and quickly to your kids, just putting them on as an owner with you on the house. So yes, when you pass away, the house will pass to the kids fairly quickly and smoothly. So it will avoid probate. But the better question to ask is that a smart idea? Is that a smart idea? And the answer is no, absolutely not. I would never advise somebody to do that. If they did that, it would be against my advice for a couple of reasons. One, you are, as the owner of the house, so as mom or dad, you are opening yourselves up to incredible unnecessary liability exposure. What do I mean by that? Well, you put your adult child on the title. They then get into that bad car accident, all right, that bad car accident. They take out that group of bicyclists riding down the road. It consists of the neurosurgeon, the tax attorney, and the investment banker, and they kill them. Now, I'm being a little dramatic, but I'm doing it to make a point. That is a bad day. That's a lot of liability that child has. There is going to be a huge lawsuit. Well, that lawsuit could come in and force a sale of that house and take half of the value. So it is, many people are sort of, maybe they read stuff on the internet, oh, just put your kids on your house. The quick and dirty way to make sure the house does not avoid probate. It is a bad idea to do, and there are much better ways to make sure that the house can pass to the kids outside of probate. Again, another question I get asked a lot.
What is an enhanced life estate and how can this avoid probate?
Okay, so what is an enhanced life estate? By the way, who asked that question? Courtney, can you tell?
John Tabor?
Hey, John. Hope you're enjoying your Friday. Great question. So an enhanced life estate deed, what the heck is that? So let me explain for a moment what a life estate deed is, or what a life estate is. If you own what's called a life estate, that is an, an ownership interest in real property, in a piece of dirt or in a home. But you don't own the entire property. You have a partial or limited ownership interest in that property if what you own is a life estate. The extent of that partial ownership interest is just allowing you to live in that house. Let's say it's a house, living in the house for the rest of your life. And then when you pass away, it'll pass directly to people that are listed in the deed, called the remainderment. So that's what we call a life estate, and if it's reflected in a deed, we call that a life estate deed. Now, there's a special kind of life estate deed called an enhanced life estate deed. Some people refer to it informally as a ladybird deed. No one's sure where that name came from, but the rumor that it originated with Lady Bird Johnson has been debunked. This is a special kind of life estate deed where the person that holds the partial interest in the property, the life estate, the right to live in the property for the rest of their life, they have some additional rights beyond just the right to live there. They have the right to sell the property. And oh, by the way, keep the sale proceeds. They have the right to rent the property. They have a right to put a mortgage on the property and some other rights. So it is almost the equivalent of owning the property itself, but in the eyes of the law, it falls just a little bit short, just a little bit short. Enhanced life estate deeds, sometimes called ladybird deeds, are sometimes used as a way to avoid probate, ways to avoid probate. And just as an aside, we often use those as part of what we call Medicaid planning, because there's a particular benefit or use of that in Medicaid planning. Now, having said that, although it's, again, a quick and dirty way to avoid a probate, there are other problems with enhanced life estate deeds. I'm not going to go through all of the problems. I'm going to mention one, and then John, I know where you live. I'm happy to have an offline conversation with you to sort of drill down as to the disadvantages for a life estate. One is what we hear from title insurance companies: they hate life estate deeds. They hate them, they hate them, they hate them. And so I don't want to sort of recommend the quick and dirty approach to avoiding probate, knowing that this might result in a title insurance problem down the road if the property ever is going to be sold. So let's say mom enters into this life estate deed, she holds the life estate, naming the kids to get it at her death. The kids get it, and they then turn around and try to sell it, and they have to get title insurance, and there's a problem. So anyway, I'll get with you, John, on that. I look forward to the conversation, maybe over in another adult beverage. You owe me one. Good question, John.
Another question asked is, are there any assets not subject to probate?
Okay, that's a great question. So again, we come back to this probate issue, and we generally try to help people, help families plan to avoid probate if they can. It's generally better to try to plan to get around it rather than force the kids to slog through it. So are there some assets that avoid probate? Well, yes. Okay. So basically there are a couple of ways to avoid probate right off the bat. Number one is if an asset is owned jointly with somebody else. So think husband and wife own something together. Then at the first death, at the first joint owner's death, it'll pass directly to the surviving owner, okay? So in that case, usually everything goes pretty smoothly at the first death because just automatically it'll pass to the surviving owner. You may have to do a couple of small things, but it's pretty easy and quick. There are two risks that are run by just relying on the fact that something is owned jointly, and this is the way that we're going to avoid probate for this asset. Number one, if both of the joint owners, whether it's husband and wife, or it could be parent, child, siblings, if they both die together. And the most common scenario would be husband and wife dying in a common accident. So what happens there? Well, that asset that would have passed easily at the first death now is going to be stuck in probate and all that. Okay. But secondly, let's say that does not happen. Let's say that does not happen, and the likelihood of a dying together in a car accident or plane crash is small. Let's say one dies first. Well, then what happens at the second death? Things aren't so easy anymore. Chances are it's going to have to go through probate at the second death. So relying on the fact that you own something jointly, in my mind, is just kicking the can down the road. Okay. Secondly, there are certain assets that will pass directly by a contract, what we call by filling out a beneficiary designation, where if you fill out a form that says, at my death, I want this asset to go to this beneficiary, it'll go straight away. Things like life insurance, things like annuities, retirement accounts, okay? So those would go straight away. So that is a way that those assets can avoid probate. Caution though, even though that asset will avoid probate through a beneficiary designation, is it best to just designate, let's say, the children as the outright beneficiaries? Or might there be some desire to protect that inheritance for them? And maybe I'll address that in a few minutes. But yes, so that's another type of asset that will pass outside of probate. The third way that assets can avoid probate, and this is a very commonly used way, okay, that avoids some of the problems with the other methods, is by the use of a living trust. By use of a living trust. And some of us have heard of a living trust. In fact, Susie Orman, who's sort of a talking head, a business talking head person on CNBC, refers to living trust as loving trust because it's a way to show your love for your family. And so what happens is, if you have a trust, think of a trust as simply a better way to put together a will. When you think about it, a will does four things. It does four very important things and answers four very important questions. Who gets your stuff, what they get, when they get it, and how they get it. Who, what, when, and how. Well, a trust answers the same four questions. Who gets your stuff, what they get, when, and how. But the beauty of a trust is, unlike if you had a will that answered those questions and your family's stuck in probate, if a trust is used in lieu of a will, again, answering those same four questions, then everything that's in the trust will pass to your heirs outside of the probate court system. Okay? Great question.
I have another question that says, I see you're offering a healthcare surrogate form. Can I do one for someone under the age of 18?
That's another great question. So what is a healthcare surrogate form? A healthcare surrogate designation, sometimes referred to as a healthcare power of attorney, is a way for you to designate someone to make important decisions for you, not financial, I'm sorry, healthcare decisions. If you're not able to make those kinds of decisions anymore, think in an emergency situation, or you've gotten to the point where you don't have the cognitive ability, the legal capacity to make these decisions, somebody can make these decisions for you. Courtney referred to us offering a free healthcare surrogate designation, which we're doing in light of this whole COVID-19 pandemic. We have made that offer that people can go ahead and sort of download that form. The nice thing is, with that healthcare surrogate designation, you don't need a notary and whatnot, because it's hard to get the notaries these days. You can basically have it filled out and signed in the comfort of your own home. And so if anybody's interested in wanting that form, then just let us know, and Courtney at the end of this will let people know how to get in touch with us. But then the question is, can that type of form be filled out for a minor, somebody under age 18? And the answer is yes. Unfortunately, it's not the form that we're making available for free. It's a separate kind of form, a separate kind of healthcare surrogate designation. And so if you're interested in that, we'd be happy to talk to you about that. The nice thing is that it wasn't always that way, where you could fill out a form like that. It's only as of 2015 in Florida that we're now allowed to do that. And what are the circumstances where you might do that? Well, let's say that you have a child that's going to be away at summer camp, and you want to authorize someone at that location to be able to make, what if there's an emergency, they're going to be taken to the hospital? Or maybe the child is traveling, on a youth trip or something like that. Or maybe you're traveling, leaving your child home with a babysitter while you're vacationing. Those are the scenarios where that would be useful. So yeah, so it's a real nice tool that we have now available to us since 2015. Okay.
The next question, sorry about that. The next question is what happens with student loans at death, particularly private student loans? Does the estate have to pay for them?
So, so government student loans are discharged. Private student loans are not. So I guess that's one of the benefits of having a government student loan. That was a short and sweet answer, Courtney.
Okay. And my divorced brother passed away, and the beneficiaries for his life insurance was his prior wife. Can this be fixed in court?
That is a great question. Great question. So, again, the scenario is that the deceased had a life insurance policy, had named his wife as the beneficiary. They then got divorced, and then he died. And he didn't get around to changing the beneficiary designation after they got divorced. So the question is, does the ex-wife get the life insurance policy? And the answer is no. And nothing needs to be done in court. So the nice thing there is the law makes very clear that with respect to things like a life insurance policy where you might designate a beneficiary like a spouse, an annuity, an IRA account, if that happens where the deceased never got around to changing the beneficiary designation, it is treated as if the ex-spouse had predeceased and had already died. And so basically it's scrubbed clean. The same thing is if there's a will where you've named your ex-spouse as the beneficiary, and then you get divorced, you forget to change your will, that's scrubbed clean. The only thing is not scrubbed clean is certain types of retirement accounts, like 401ks, okay? Any retirement accounts that are governed by a certain federal law, there it's not automatically scrubbed clean. The good news is that usually in a divorce situation, one of the things that's put in place before the divorce is finalized is, if you have a good divorce lawyer, certainly that they'll make sure this is done, to make sure all those beneficiary designations are changed and certain court orders are entered into, called qualified domestic relations orders, or quadros, to make sure that the ex-spouse is removed from any benefits under that. Good question.
Okay, we have another question that says, what if my husband and child die at the same time as me? What happens to my estate?
What happens if my husband and child die at the same time? So whose estate are we talking about?
They're saying that themselves, their husband and their child all pass away at the same time. What happens to their estate?
Oh, okay. So husband and wife and all children die at the same time. I'm going to
Correct.
interpret the question that way. So, well, it then depends on if you have a will or a trust in place. So you have something in writing that's legal and valid and legitimate. Then hopefully that legal document has specified where it's going to go, next. If you don't, then both husband and wife, their collective assets are going to have to go through probate. They're going to go through a special kind of probate called an intestate probate. They will die what's called intestate. Intestate simply means dying without a will. Whereas if you die with a will, then you have died testate. Without a will, you died intestate. There, Florida law will dictate where it goes. And it's funny, I sometimes joke with people, okay, you don't have a will in place. That's great. So do you think that means you don't have an estate plan? Do you think that means you don't have an estate plan? And they would say, yeah, I don't have an estate plan. I don't have a will. I said, oh, no, yes, you do have an estate plan. It's unfortunately the plan that the state comes in and tells, your family who's going to get what. So, so you have to follow the state law. So in that case, if memory serves, no surviving spouse would go to children, no surviving children. It would then go upstream to any surviving parents, if any. If none there, it would go out laterally to siblings of the deceased, husband and wife. And if none there, then you'd look at nephews and nieces. And after that, I'd have to look at the statute. Let's hope that doesn't happen.
Yes, let's hope that doesn't happen. Right now we have no other questions. Oh, wait, one just popped up. There we go.
Okay.
Hold on. It says, upon my mother's death, father already deceased, are my dad's irrevocable trusts responsible for paying in full a $100,000 unsecured line of credit held by a local bank? Payments continued after his death. Not sure if she is a co-signer and not sure if that makes a difference currently and in the future as far as payments. Thank you.
I tell you what, can you throw that question up so I can read it? That's a long one. I'd like to read that again.
Okay. If you go over to the questions tab, you'll be able to see it. It's the one in there.
So bear with me, folks. I'm a newbie at this. That's why Courtney is running things. So, okay, here we go. Upon my mother's death, the father is already deceased. My deceased dad's irrevocable trust, are they, the question is, responsible for paying in full a $100,000 unsecured line of credit held by a local bank? Payments continued after his death. Not sure if he is a co-signer and not sure if that makes a difference currently in the future as payments are concerned. Well, I don't know if I completely sort of understand the specific facts, but I will say generally here that if we're talking about whether your deceased father's irrevocable trust in place at your mother's death had some obligation to pay a debt, that would depend on the terms of that trust. It would depend on the terms of that trust. And if the line of credit was held by your mother and it was unpaid at her death and the bank was calling that line, it would depend on the terms of that irrevocable trust as to whether there was a payout that was to be made to your mother or your mother's estate or your mother's successors at her death. So it's really kind of hard for me to answer that question. If you'd like whoever that is to talk offline about that, I'd be happy to do that.
All right, another question we have is, do you also offer a formal updating and or maintenance program for if things change and my plan needs to be updated?
Okay, that's a great question. So let me, I guess I'll sort of ask the question, which is, let's say an estate plan is put together for somebody, and let's say it is a revocable living trust, which I've already talked about, which is a wonderful alternative to a last will and testament for many people, particularly middle-aged and older, okay, for a variety of reasons that I haven't had time to go into all of those. But let's say a trust is put in place, today or next week. A trust is put in place. And we've made sure that that trust is all buttoned up by making sure the assets are put in the trust. So, at a certain point, the trust is in place, it's locked down, and all the assets are buttoned up. The question then to ask of the person that has just put that trust in place is this: when do you think that trust really needs to work? When do you think it really needs to work for the way that you want it to work? And the answer is not necessarily today, tomorrow, or the next day. Although I reassure people, don't worry, any trust that I put together is going to work for you today or tomorrow or the next day. But no, when it really needs to work is when you pass away. When you pass away or you become incapacitated. Those are the two scenarios or circumstances when it needs to work. So really, confession to make, I don't know when that's going to happen. I don't know when that's going to occur, when someone's going to die or become incapacitated. And my guess is that the client sitting there with me, if I ask them that question, they aren't going to be able to answer that question either. So to put a trust together that's going to work not only today, but at some unknown time in the future, when things may change, family circumstances may be different between now and then. Assets may change. So maybe some new accounts open up in the future need to be put in the trust correctly. The law may change. There was a major change in the law that happened effective January 1 of this past year, the tax law that applies to IRAs. We could not have envisioned that 2 years ago. So to put a trust in place that's going to work not only today, but at that unknown time in the future is kind of a tall order. So the solution to that is for the client to stay close to the lawyer, allow us to sort of walk with them on their journey moving forward, to allow us to help them adapt their plan as things change. And our particular solution to that challenge is what we call our client care program. And so that's really a reflection, to be honest with you, of the nature of this firm, this practice, and my practice philosophy is that I choose to work with clients that sort of want to develop a relationship so we can sort of move forward with them, rather than somebody that's just looking for sort of a one-off transaction and they're coming in just to, put money in the meter to buy a document. That's a great.
I'm happy someone brought up the client care program, since I work with those clients closely. So the client care program is definitely a benefit that you get working with Legacy. Another question we got was, at what age do you believe a trust should be put together?
Oh, that's a great question. That's a great question. There's no hard and fast rule, but I would, if I had to sort of, pick an age out of the air, I would say probably 50 to 55 and up. I don't believe in sort of overcomplicating advice, but only to give the advice, the planning advice that is suitable. Okay. Does a couple in their 30s with small children need a trust? Well, most of the time, no. They can do just fine with last wills and testaments, with wills. Very important that they get those in place. So at a bare minimum, they have designated guardians for their kids if something were to happen to them. Okay. But wills oftentimes is more than adequate. And then as they sort of move along, and I say, well, let's look at putting wills together for you now. And when you get into your 50s or 60s, then you can consider revisiting with a trust. Certainly, once you're in your 60s and certainly into your 70s, I often will have the trust conversation. And unless their particular circumstances really doesn't justify it. Maybe they just own a house and that's it. If they have a very simple situation, then a trust would not make sense. But certainly, if it's a little bit more involved, certainly if it's a second marriage where one or both have children from a prior marriage, I'm going to have the trust conversation with them. I'm going to lay out the options so that they then can make their own decision. And I make sure that the decision they make is an informed one. I believe in giving options, and then you pick the option that you think is best. Okay.
Okay. One question is, what are some scenarios where we must come into the office and virtual meetings are not an option?
Oh, okay, great question. Well, so obviously we are doing virtual meetings. Heck, we're having this right here. We really were not doing much of this before all of this started, but I think this is going to be sort of a new thing that we are going to start doing on a regular basis. I think it's just the new world we're in. Before the coronavirus, we would meet with prospective clients in the office. And that actually is a very good thing, because you're sitting across the table, make eye contact and so forth. But right now, it's very difficult to do that. It's almost impossible unless we have an emergency situation. So we are holding virtual client meetings. I've had a number of them. They've actually gone quite well. In fact, I think both the client and me, we've been very pleased with how smooth it was. I'm able to sort of use a whiteboard to show them, to simulate almost the same experience they would have coming in here. Okay. With respect to the finalization and the signing of documents, we're basically having to put those off until May at this point, unless there's an absolute emergency. We did have one yesterday, and we had a system set up where we actually had one person outside of the office on the other side of windows that were open, and so they could actually see as a witness the signing of it. And so, we're maintaining all the CDC guidelines, but the preference would be not to have somebody come in, but hopefully convince them of the ease of use of doing a virtual meeting.
And the next question, also dealing with the coronavirus pandemic, what are the most important documents to get in light of this virus and pandemic?
Well, I think the most important are to have your advanced directives in place. Your advanced directives. So many of you may have heard of that term, advanced directives, not exactly knowing what it is. It basically is, it's a collection of documents. We call them here as part of our incapacity planning package, incapacity planning documents. And basically they consist of four things, okay? Number one is a durable financial power of attorney. So this is the power of attorney where you appoint someone to make financial decisions for you. So think, boy, you have been stricken by this. You are laid up in the hospital. And you don't have to be, frankly, you don't have to be 75, 80 years old plus to feel that you need this. I just read a story this morning that some of you may have seen, our own Tony Baselli, Jaguar great. Although he's in his late 40s now, still very fit, very fit. He was laid up for 5 days with the coronavirus at Mayo, and said it knocked him on his fanny. It knocked him down. I don't think he was in much of a position to be making decisions. So a durable financial power of attorney, a healthcare surrogate designation, sometimes also known as a healthcare power of attorney. Okay, again, this is now you're empowering someone to make healthcare decisions. So it's not the financial decisions, but the healthcare decisions. If we break those out into separate documents, we have a separate what's called HIPAA release. HIPAA is the medical record privacy law, where that's why doctors and hospitals won't talk to you or make it very difficult if you're inquiring about someone else. With a HIPAA release or HIPAA waiver, you can list people that you are saying to the doctors in the medical community, I want them to have access to my medical records. So you are to talk to them. You are to release my records. So that's a separate thing that we do. And then lastly, something called a living will. A living will. Now, don't confuse it with a last will and testament. The last will and testament deals with your stuff. the who gets your stuff, what, when, and how. A living will, think of it as the end of life document. It's a way for you to express your wishes for the kind of medical care or medical treatment that you want, or perhaps that you don't want if you are, close to death, or you have a terminal condition, that sort of thing. So those four really can be loosely called advance directives. Okay.
And I went ahead and advanced to the next slide. Since we are talking about packages and everything, I figured this would be a great time for you to talk about our two different programs, one that's on the probate side and one on the estate plan.
Yeah, as we bring this to a close, I just wanted to share with you, we are very proud of our two very unique processes we have. I believe in process. I believe in sharing with our clients a process to show them the journey they're going to go on in visual form. It's very helpful rather than somebody sort of plunging into a planning, not knowing where they're going to, not knowing the road they're going to go on. So on the left-hand side is our family estate and legacy program. It's a unique 7-step process starting at the top. Step 1 is our organizer, so that sort of gets the ball rolling, where you put some information together, you get it to us. We move over to step 2, called our goals and responsibility conversation. So we identify, what are your goals? What are your concerns? What would you like to accomplish? And then we call it the responsibility conversation. Sometimes it's easy, sometimes it's not so easy. Who do you want to assign different roles? Who do you want to be responsible to do what? Okay. Then we come down to step 3 in the green, the design step. So we actually design your plan. What is the will going to look like? What is the trust going to look like, and so forth. Then we shift over to step 4, the purple, called the document builder, where we put documents together, put pen to paper. Step 5 is something that I believe in very strongly, called the advisor coordinator. So to the extent that the client's working with, let's say, a financial advisor, perfect example, maybe a CPA. Consider letting me plug them in early on in the process, because I believe in the team approach. More than, multiple heads are better than one. Then we come around, step 6 is called the alignment process, and this comes into play when we put a trust together. Is you can have the best trust in the world, but if your assets are not aligned with your trust, whether put into the trust or otherwise aligned with your trust, and your trust isn't going to work. So we provide alignment, asset alignment services. And then that client care program that I mentioned, that's sort of the final step of the planning process. And from there, we sort of move forward together with the client so that we can adapt their plan as things change in their life. So that's the family estate and legacy program. That's our planning process. On the right-hand side is the estate settlement program. So now you have a family member who has passed away. Well, what needs to be done? Sometimes it's pretty straightforward, but other times they didn't do the proper planning. So there's a process, whether it's dealing with the probate courts, or maybe they had a trust and passed away, and now that trust needs to be administered. So it's a process. It has 7 steps as well, where we start off with the snapshot meeting, where we sit down with them and explain our estate settlement program with them and see if they would like us to help them administer the estate. If they move forward with us, we go to step 2, called the legal module, where they share with us what legal documents are we talking about. Did they have a will or not? Did they have a trust or not? So we know what we're looking at. We get that ball rolling. We then move to step 3, called the assets module. So we ask the family to pull together information about the assets that the deceased had. Very important that we need to know what those are. Step 4 is a critical stage in the process when someone has died, called the creditors module. We need to make sure that all of the deceased bills are paid, and any creditors they may have had, or even creditors that maybe they have but they didn't know about and we may not know about. We need to create a process where we give them a chance to step forward, put them sort of on the clock. So if they have a claim, they can submit it. And if they don't submit their claim in a certain period of time, then they have to forever hold their peace. So we want to clear creditors to give the family peace of mind, knowing that they're not going to have some creditor coming in after the fact. Step 5 is the taxes module. We often have tax issues to have to deal with, so we plug in the CPA. Then we get to step 6, module 6, the distributions module. So here, once we've sort of gone through the other steps, now the executor or the trustee can go ahead and make the distributions out to the to the beneficiaries, and then 7 is the wrap-up model. So again, these are 2 very unique processes, both on the planning side and then on the post-death administration side that we are very proud of. So thank you for bringing that up on the screen, Courtney. So I know that we are coming to the end of our time. So why don't you go ahead and sort of close us out here, Courtney. Oh, there was one thing I did want to mention before you close it out is what I'd like to do is, if anything I have said sort of has piqued your interest and you'd like to sort of take the next step, dive a little deeper, Courtney in a minute is going to tell you how to give us a call and schedule a phone call with us. But if you end up getting to the point of wanting to do some planning with us, and especially if you end up wanting to put a trust together with us, and we'd have an opportunity to explain what a trust is, what a trust does. But if you get to the point of wanting to retain us, then what I'd like to do is give you a $250 gift certificate off of any trust planning services. You would just need to tell us that you've watched this webinar and use the code that appears there, Legacy Happy Hour. Pretty catchy, Legacy Happy Hour. And so if you do that, we'd be happy to honor that gift certificate. Again, if you want to take the next step, give us a call, talk to you, and end up having a consultation and decide to go ahead and move forward with us. Okay? So with that, I'm going to turn things back over to you, Courtney. Courtney.
I'm back on screen now, and so we wanted to do a couple of things. This is how you can get in contact with us. But before we do that, I want to do the last poll of the evening. And that poll is quite simple. That's a, well, maybe not. Maybe I don't get to do the poll. Went away.
Oh, it was a good one too.
Yeah, it was good. It was asking you how you're feeling. But if you don't mind, you can always throw it in the chat how you're feeling. If you're happy, you're confused, you feel motivated from us. Or maybe you're sleepy or hungry because we're getting to that hour. If you want to throw that in the chat, that was what our poll was for the evening, was just trying to gauge how you felt after hanging out with us for the afternoon. But one thing I want to say is thank you for everyone that came. And during the virus, we are conducting virtual meetings, as Bill had said. We have already had several, and they are going very smoothly. We'd be happy to schedule a virtual meeting with you, or if you would like to talk to us about your particular situation or whether our estate and planning services might help you in any way, you can give us a call at 904-880-5554 or go to our website, legacyplanninglawgroup.com. If you'd like to book a call directly, you could just do legacyplanninglawgroup.com/book-a-call. That's also up on the screen. So those are the ways you can get in contact. And once again, this is our team, and we wanted to thank you. As you see, Bill is surrounded by a lovely group of women, and we keep him in line.
Okay, I tell you what, before you close this out, again, I want to thank everyone for coming. I know this has been a very, I don't know what the word is, not disconcerting, but a very strange time, and we're adapting as best we can. I just hope and pray that when we are finished this and we go back to our lives as before, maybe we're going to wash our hands better than we did. I think that's probably going to be a good outcome. I hope we take this term social distancing and throw it in the trash heap of history. I am tired of using that term, and I look forward. I think we're going to have a great, great summer. So thank you all for coming.
All right, thank you. Have a good night, everyone.